As in many ways, when it comes to the 2011 death of Mangum's boyfriend Reginald Daye, the case is one of exemptions. For more than 7 years, Dr. Harr has been attempting to present evidence of Crystal Mangum's innocence to Attorney General Governor Roy Cooper. And for more than 7 years, Mr. Cooper has ignored Dr. Harr. An advocate for Mangum, Harr's repeated letters to Cooper went unanswered, and his frequent attempts to get an appointment to meet with Cooper or one of his high-ranking officials were futile. Even a letter addressed to the receptionist for Governor Cooper, which sought an appointment, was immediately returned to Dr. Harr unopened. One of the earliest pieces of correspondence sent to Roy Cooper was in July 2012. It was a 30-plus page formal complaint which included evidence of Mangum's innocence in Mr. Daye's death. Several more letters seeking to present evidence of Mangum's innocence were delivered to Roy Cooper, the latest by certified mail on May 7, 2019. Like the rest of Harr's communications to Cooper, it went unanswered. Dr. Harr, in his 7-year endeavor to present evidence of Mangum's innocence, was totally ignored by Roy Cooper. Cooper set the tone for other prosecutors to follow when it comes to Crystal Mangum's case. NC Attorney General Josh Stein has, likewise, ignored Dr. Harr's writings and attempts to confer with him and or his high-ranking staff. Many years ago, when Mr. Stein was a legislator, emails to him about the injustice in Mangum's case went unanswered. Current Durham District Attorney Satana Deberry, shortly after her election in May 2018, responded to an email from Dr. Harr stating that she would entertain his concerns about Mangum once she was sworn into office. Though Dr. Harr felt he was being brushed off, he waited. Shortly after Deberry took office, Harr tried to meet with her, with the usual results. Dr. Harr sent emails and traveled to Durham in an attempt to meet with her. Deberry's assistant told Harr that the district attorney was unavailable to meet with him and that the office would get in touch with him. Not surprisingly, it didn't. The truths of Mangum's case, which are primarily derived from prosecution discovery, are compelling, just a few of which are as follows. 1. The stab wound Mangum inflicted had no nexus to Daye's death. 2. Duke University Hospital was responsible for Daye's death due to an errant esophageal intubation, medical malpractice. 3. The autopsy report by Dr. Clay Nichols was fraudulent, with fabricated findings and a false conclusion. 4. 4 of the state's star witnesses against Mangum committed material perjury. 5. Defense attorneys for Mangum withheld exculpatory information from her. 6. The defense expert witness forensic pathologist Dr. Christina L. Roberts wrote an inaccurate report to assist in her client's murder conviction while shielding Duke University Hospital's responsibility for Daye's death. 7. Trial Judge Paul Ridgway withheld from defendant Mangum an 18-page document from Dr. Nichols' personnel folder which the Black Rober believed to be germane to her case, and much more. It's not that Governor Cooper, Attorney General Stein, and Durham District Attorney Satana Deberry do not know these truths, because they do. They simply do not want to be confronted by them. They would rather profess ignorance of the injustice than acknowledge their complicity in it. Put another way, in the Clive Cussler Justin Scott novel, The Striker, the protagonist said, "Knowing what is right is not enough. If you know what's right, you have to do right." Governor Roy Cooper, Attorney General Josh Stein, and Durham District Attorney Satana Deberry don't want to do what is right for Crystal Mangum. So, at least for appearances, they don't want to be informed of the truths and facts of her case. That is why, for more than 7 years, they and others have declined to allow Dr. Harr an audience. A staffer for former North Carolina Lieutenant Governor Walter Dalton confided that they had 2 directives when it came to Mangum's advocate, Dr. Harr. Don't schedule him an appointment and never give him anything in writing. For the state officials to carry out the manifest injustice against Duke lacrosse accuser Crystal Mangum, they required the cooperation of the courts and media. Court partiality is necessary for desired outcomes in complaints filed by Mangum pro se, be it a motion to dismiss an indictment lacking in probable cause, a habeas corpus petition, or a malicious prosecution order placing trivial technicalities before a meritorious fact-based civil complaint. Bias in the media is a requisite to keep the public misled and or uninformed about the truths of Mangum's case. Its selective, suppressive, and slanted reporting can not only defame the innocent, like Mike Nifong and Crystal Mangum, but lay out false facts in support of a journalistic agenda, such as perpetuating the Duke lacrosse myth. That myth consists of Mangum lying about being sexually assaulted at the party, Nifong prosecuting solely for political gain, and the 3 lacrosse players being victims of Mangum and Nifong. As Roy Cooper told CBS's Lesley Stahl, it is a mistake for a prosecutor to refuse to hear evidence offered by the defense, especially that which is exculpatory. But that is precisely what he and other state officials have been doing for more than 7 years. Not only does it constitute a grievous injustice to the innocent, but it destroys the integrity of the justice system itself. A prime example being the armed robbery kidnapping conviction of O.J. Simpson and his lengthy prison sentence by the Las Vegas justice system. Obviously an instance of a vindictive prosecution as payback for what was widely perceived by the public to be a wrongful verdict in his murder trial for the deaths of his wife and Ronald Goldman years earlier. The justice system should not be used by vigilante prosecutors and courts as a means to avenge legal outcomes that many find disagreeable. It's unethical and wrong for the Las Vegas courts in Simpson's case, and it's just as unethical and wrong in the North Carolina courts. In Mangum's case, those in power wanted her convicted of first-degree murder and given a mandatory life sentence in retaliation for filing a false police report against the 3 Duke lacrosse defendants. This despite Mangum steadfast asserting that she was truthful about the 2006 sexual assault. Governor Roy Cooper, Attorney General Josh Stein, and Durham District Attorney Satana Deberry continued to avoid the evidence and truths of Mangum's innocence, ignoring Dr. Harr and not being challenged by the media, politicians, clergy, and civil rights organizations. Roy Cooper's double standard for refusing evidence of innocence from defense attorneys. What's wrong for Nifong in the Duke lacrosse case and prosecutors in other cases is acceptable and advisable in Crystal Mangum's case. Not being confronted by evidence of innocence represents the grand plan of Roy Cooper and the state of North Carolina, while running out the clock until Crystal Mangum has served the entirety of her prison sentence with a release date in 2027.